Welcome to Advocacy Exchange, Navigating Injury Texas Law.
Hey everyone, welcome back to an all-new episode of Advocacy Exchange, Navigating Texas Injury Law with Paul Littleton. I am your host, Mike Leon. Paul here is the Director of Business Development and Operations at Littleton Law Firm, where he helps guide strategy, client communication, and case management all across the firm. Today's episode, we're going to be talking about what insurance companies actually look for before they decide whether to take an injury claim seriously. I have an assumption that you shouldn't be posting on social media. We're going to get into that in just a second, Paul, but it's good to see you. So let me ask you here, when an insurance company first receives that initial claim, what are they kind of evaluating in those early stages before they decide how much attention to give the claim?
Well, most insurance companies look to the information provided at intake, when you file the claim, and they're looking at factors such as whether the car is drivable, whether somebody went to the hospital, whether they were taken by ambulance when they went to the hospital. They're looking at if there's a police report. Like there's a few key identifiers that will kind of place the case in their evaluation systems that they use, like Colossus or Injury IQ, depending on the insurance company. But these value drivers kind of factor into where they categorize the claim and what adjuster they assign, because adjusters will have different levels of authority and what their training will enable them to do. But the idea here is that sometimes giving them the information needed to navigate the claim early on best will actually help them much later on. For example, if the car is not road safe, but it was drivable, right? That kind of puts it in better perspective for the insurance adjusters so they don't place the claim in a smaller evaluation from the onset when it may have been like a bad accident, let's say a rear end accident that maybe wouldn't have disabled the vehicle, but definitely would have caused some damage.
Yeah. From your perspective, what has separated your experience doing this? What has separated a claim that kind of gets delayed or maybe even discounted from one that gets those immediate alarm bells to kind of go off that this one needs to be handled a little bit more carefully?
Usually, what will kind of sink or the case very quickly, especially, but when it shouldn't have been, in my opinion, is what the insurance companies called MIST claims, and they like to evaluate these claims. What the abbreviation stands for minor impact soft tissue injury, and what they look at is basically the mechanism of the accident as far as like the property damage. Let's say it's small, right? Which is, oftentimes can be just factored on what the cars were driving. An SUV may not have as much damage as a Toyota Corolla, for example. And as a result of that, they look at that the people in that SUV weren't injured because the property damage was substantially less. And so they'll turn around and claim or put them in a category where they could have only sustained soft tissue injuries. The catch to this whole thing is that unless you have an immediacy of broken bones or, internal bleeding or something that would have definitely put you in a category where your injuries were considered life threatening, everyone starts off with soft tissue injuries because the only thing that at that point is that you're hurting in your neck, your back, or your shoulder or your leg. And until when you're filing the claim, you don't have diagnostics, you don't have anything to confirm that there's nothing but soft tissue. So really, all claims start off as soft tissue, but they take advantage of that and connect it with the minor impact, and they will claim it as an MIST claim. Now, the MIST claims are often beat when you have a client that maybe the property damage is minor, but they have a pre-existing history or prior condition that would kind of further their injury from far less of an impact. If you disclose that early on, then you're able to kind of beat these categories that are unjustly placed on claims from the onset without proper information.
Mm. Let me ask you as well, how much early on does documentation and the consistency matter in maybe shaping how the insurance adjuster that you mentioned earlier views the case?
As soon as possible. So what we do, a common practice here is that we will turn around and we'll file the claim, but we never want to rely on the person who did that filing, with the insurance carrier to have done their job as thoroughly as we had hoped with the information we provided them. So we always follow up with a secondary letter that just specifically covers our client's injuries and includes whether they had any prior medical conditions or prior accidents that would have contributed or aggravated, kind of delineating between causation and aggravation as far as the injury, and as well as whether they went to the hospital, whether they're a recipient of Medicare, Medicaid, or private healthcare insurance. The age of our client, what they do, so that they can understand potentially the duress that our client may suffer from having injured themselves, but having a job that requires manual labor. So you have all these different factors that we kind of like to inject early on in writing as soon as the claim starts, because they just really help navigate it in the right place.
Paul, can I ask you kind of along those fronts, what are some maybe gaps or some red flags that have caused insurance companies to start questioning the strength of a claim, even if somebody was clearly injured?
One of the, it varies. I'm going to just be honest with you. It kind of varies from time to time. It seems like when the economy gets a little bit tight, they seem to try to track down little nuances that they feel mean something. And I'll give you an example. Just recently, we had an adjuster question that the client had went to an urgent care the same day that they hired us, and so they felt that the client's, urgent care uh, visit was kind of attorney sponsored rather than medically necessary. And to be frank with you, when the clients come to us and they're saying, look, I'm in a lot of pain, I don't have any health insurance, what can I do? The bottom line is I can only tell you what I would tell my family. If they were in a lot of pain and needed immediate care, I would tell them to go to an urgent care. I wouldn't tell them to go to the hospital unless their life was really in the hinge there, because hospitals can take a long time to treat you. You don't want to be there for hours and hours. But getting noted in urgent care usually results in some sort of injection of Toradol or some sort of anti-inflammatory or pain medication that will help them, at least for the onset of the 24, 48 hours, until they can get to be seen by their regular doctor or their PCP. So that in of itself is a flag that the insurance companies kind of use sometimes. This in just recent cases, as something that they should pay attention to. But in reality, it's just the most common sense thing to do. If you're in pain and it's that significant, go to the urgent care so that they can provide you some sort of documentation and treatment, pain management, really, for what you're going through. Um, but it's those types of things, those types of nuances where they just kind of look at something and they just make up a story or assume a story or narrative that's not necessarily true. But it, to me, is just a common sense response.
Paul, staying on the insurance claim itself and your work and what you do, how does the way a case is presented differ when you're preparing it for that insurance review versus you're preparing it to now go to trial?
So, well, there's a big difference between claims and actual litigation. There's a sea of differences, because during the claims process, they use those computer systems like Colossus or Injury IQ to evaluate the claim quickly. And this thing will run through the codes of treatment as well as the codes of billing to determine if there's any irregularities or abnormal things that are abnormal in the records. They will use value drivers, like if the client is, what the client's weight is, what the client's height is, whether or not they were male or female, because they have information such as like whether the seatbelt would be placed properly on a woman maybe that's 5'4" versus a man that's 5'9", depending on the vehicle that they're in. They have the mechanisms to be able to determine whether or not the juries would evaluate the case where, let's say, our client is the sole provider of their family and sustained lost wages. They factor things like whether or not the how long they were on medication versus whether they were prescribed medication. And so all these things go into the claims evaluation of something, and it comes out with a number or scale that they get authority for. But one other thing that they do, this computer program does, is adjust the medical to what they consider reasonable and necessary, which is oftentimes this Medicare, Medicaid standard, which is not the rule of law. Medicare, Medicaid, or government sponsored programs, and not necessarily the standard of what healthcare cost should or is in any given state or city. But on the jury side of things, when we go to trial, when we're litigating the case, all of that goes out the window, because now they're dealing with potentially 12 people, not computers. And these people are going to infer, they're going to assume, and they're going to relate to whatever experiences the attorneys are able to give them on the claim. And that can be very dangerous. So the way we present a case in terms of the claims is we're providing all of the information and that we know their algorithm wants or needs to make a proper evaluation. And in our firm, we're largely successful in that, having the majority of the cases end up settling for policy or close to versus, having to litigate it because there wasn't enough money offered. As far as the trial setting is concerned, we definitely focus on the presentation of our client in terms of the relatability, the common sense responses, because we know that if the jury can relate or at least find some common ground with our client in some manner, that they will provide their good faith, honest opinion or help in that particular circumstance. But if we have a client that can't or is not relatable, if we have circumstances that just are above and beyond what the normal prudent person would be, it makes things very difficult. So we always try to make sure that we're navigating from that agenda, from that objective, relatability more than anything.
Yeah. Paul, speaking of case, obviously within a case, there's investigation, there's evidence collection. How do those two things kind of potentially influence an insurer's willingness to engage meaningfully instead of minimizing like the claim like they often do?
Well, so it used to matter a lot more than I think it does now, only because insurance companies now write policies that have disclosures that indicate they will not pay for punitive damages or any punitive damage element. So when so let's say our client got involved in an accident where there was a drunk driver, and we used to be able to include that information and used to have more weight. They would pay more for a claim where their insured was drinking and driving or committing some sort of offense like that. But now, because they don't pay for punitive damages and everyone still has to buy policies under these guidelines, they don't provide as much weight or merit to it as they did before. So really, the evidence that we utilize that does kind of have a bearing on it is that they're insured either lied, didn't tell the truth about something or fact. That we can prove with that evidence, even if it's from an expert's point of view or accident reconstruction his point of view, especially for those things, because we'll double in on their testimony. The whole idea is that if we're presenting a claim and the insurance company knows that the common prudent person would be upset at having to go through something because their insured didn't tell the truth, they're going to be more likely to settle the claim than not.
So let me ask you, Paul, as we kind of put a bow on this episode. When you compare cases that get the engagement from the insurance companies early on versus those that don't, like we've been talking about this episode, what are some common through lines or some differences that tend to show up in how those cases, were prepared at the onset?
Well, one of the most so the insurance companies that insure a certain type of demographic, and I'm going to say like the ones that offer the liability policies for $69, so to speak, and sell them at gas stations and things like that. Those insurance companies know that subset of demographics are going to be very hard to reach when the claim needs to be or is going into litigation. So what they have is they'll work under something called reservation of rights, and this is an insurance company's loop to get out of paying on a claim, not based on the actual fault of their insured, but simply stating that their insured hasn't cooperated with them, hasn't given them a statement, hasn't engaged with them like they should, like it's defined in the policy. And so what they do is they work under reservation of rights, indicating that they're no longer bound by the policy to pay for the negligence of their insured. Early on, when you're doing the investigation, you're doing the onset, if the insurance company sees that you're willing to go and hire the investigator to find their insured who may, live in an apartment and move 6 months later, for example, or, maybe in jail or, whatever the circumstances, if they know that you're going to go that mile, then they typically will avert and settle the claim. But sometimes if you don't do that, they just hope that the attorney will wait close to the statute or whenever the case is over. And then by that time, their insured's long gone somewhere else and it can't be found.
Yeah. Paul, it's great insights and analysis on all of this. I appreciate you kind of breaking this down for the audience. Thank you.
No problem. Thank you.
And that's it for today's episode of Advocacy Exchange, navigating Texas's injury law. If you've been injured, and I sound like the billboard, if you've been injured and you want to understand how your case will be evaluated by insurance companies, the team over at Littleton Law Firm, they're here to help you navigate that process with clarity and care. Do me a favor right now, visit littletonlawfirm.com to learn more or to connect with the team. And do me one more favor before you go. Hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.